Hello students, welcome to the Hindu News Analysis by Baji IAS Academy. Today we will discuss some of the most important and most relevant news articles they are given in the Hindu newspapers. So before actually discussing these news articles, please subscribe to Baji IAS Academy YouTube channel so that you will get all important updates regarding all our classes. Okay, so these are the list of important news articles right from the welfare spending has been getting a regulate pruning. Okay, so this is with respect to expenditure on welfare programs by the government of India. The next article is top court, that is Supreme Court ruling on services is a boost for representative government in Delhi. Okay, so this is with respect to the tussle between the union government and the elected government in Delhi. The next important news article is Supreme Court tells courts not to rely on April 26 order on default bail. Okay, so as part of this article, we will try and understand what exactly is the default bail and why Supreme Court says the other courts to not to rely on the default bail. So next article is Center prepares a new model prison act with focus on reform. Okay, so this model prison act is very important and this is prepared by the Ministry of Home Affairs. Okay, so this will replace the colonial era prison act. So next article is lack of committees against sexual harassment in disquieting Supreme Court. Okay, so in Vishaka Guidelines 2013 and prevention of sexual harassment of women at workplace, there was a mandate, okay, a legislative mandate to constitute internal complaints committee in every organization with 10 or more women employees. Okay, 10 or more women employees. Okay, so as part of this article we will try and understand why Supreme Court expressed disquiet over displeasure over the internal complaints committee and the functioning of the prevention of sexual harassment of women at workplace act. And this is with respect to inflation, and inflation slows to an 8-month low of 4.7 percentage. Okay, so these are the list of all important news articles today we are going to discuss. So the first news article is with respect to the expenditure by the union government, on various welfare programs. So this article has been emphasizing on since 2014. Since 2014, the expenditure on welfare programs has been significantly declined. Okay, so this article has been emphasizing on the union budget was criticized. Why it is criticized? Because a decline in allocations for welfare schemes by the union government. Because after the COVID-19 pandemic and for the recovery from the impact of the COVID-19 pandemic, welfare spending should be a top priority. Even though the welfare spending should be a top priority, the government has not been giving adequate amount of money for various welfare programs. Okay, so if you look at the last year budget, it, the last year budget has effectively ignored the social spending in favor of the capital expenditure. Okay, so there was a negligible or very minute amount of capital expenditure on social spending on capital expenditure. So whether it is with respect to education, healthcare, employment generation, etc. Okay, so central allocations for welfare schemes and sectors that ensure basic rights have declined in proportion to GDP. Whether it is Mahatma Gandhi National Rural Employment Guarantee Act, midday meal scheme, education, midday meal midday meal scheme, education and healthcare. Okay, so they provide basic rights to individuals, and the budgetary allocations have largely ignored these basic programs, and their allocations have been significantly declined over on a proportion to GDP. Okay, so for example, if you look at the Saksham Anganwadi and Post 2.0 schemes, so these schemes are basically aimed at child malnutrition and hunger. Okay, So they primarily aimed at addressing the child malnutrition and hunger. So these programs, Saksham Anganwadi and Poshan 2.0, allocations have went down from 0.13 percentage of GDP in 2014-15 to 0.77 percentage in 2023-24. Okay, so therefore almost half the reduction in allocations for both Saksham Anganwadi and Poshan 2.0. Now, apart from this, according to a data from the National Family Health Survey, the percentage of anemic, underweight, and stunted children is respectively 67 percentage, 32 percentage, 36 percentage. Okay, so this is India has a worst levels of anemic anemia affected people, and this is primarily because of poor allocation of funds to prevent anemia, underweight, and stunted children. This is primarily because of excessive levels of malnutrition among children, okay, and also the adolescent girls. However, if you look at the midday meal program, midday meal scheme provides nutritious food to school students. Okay, so this covers 12 crore poor children who are attending the schools, and midday meal scheme also aims at improving the enrollment ratio in schools. Okay, it will also provide nutritious food, thereby reducing the dropout rates in schools. Okay, it will reduce dropout rates in schools. Okay, so some of the objectives or aims of the midday meal scheme include improvement in class attendance, learning as well as nutritional outcomes will improvement, and also reducing the stunting among children are some of the objectives which are mentioned as part of the midday meal scheme. Okay, so if you look at the budgetary allocations for midday meal scheme, they have decreased by around 50 percentage. Okay, so these allocations have been decreased by 50 percentage as a share of GDP from 0.08 percentage in 2014-15 to 0.04 percentage in the year 2023-24. Okay, so the next flagship scheme is Pradhan Mantri Matru Vandana Yojana. Okay, Pradhan Mantri Matru Vandana Yojana. So this scheme provides a maternity benefits as a conditional cash transfer of 5,000 rupees. Okay, 5,000 rupees per woman in the unorganized sector. Okay, so budgetary allocations have also declined for this scheme. Okay, so data suggesting that this will cover all women and births as per the National Food Security Act mandate. Okay, so this scheme needs around 14,000 crore. Okay, this scheme needs around 14,000 crore, but Pradhan Mantri Matru Vandana Yojana budget is yet to cross 3,000 crore. Okay, so the overall requirement for the implementation of Pradhan Mantri Matru Vandana Yojana is 14,000 crore, but the budgetary allocations is around 3,000 crore. So therefore, it is significantly lower than the required amount for the implementation of Pradhan Mantri Matru Vandana Yojana. Okay. So apart from these concerns, we also have a working class distress further worsening. Okay, so this is primarily because of the Mahatma Gandhi National Rural Employment Guarantee Act, and the food subsidy bill is further reduced through allocations. Okay, the allocations have been further reduced in Mahatma Gandhi National Rural Employment Guarantee Act and also the National Food Security Act. Okay, so as a share of GDP since 2014. Okay, since 2014, the allocation has been significantly declined. However, please understand the objectives of Manrega. Mahatma Gandhi National Rural Employment Guarantee Act guarantees 100 days of employment to every rural household. Okay, it guarantees 100 days of employment to every rural household, and National Food Security Act provides subsidized grains to around 80 crore population. Okay, so the data suggesting that both Manrega and the National Food Security Act, that is providing food grains, subsidized food grains through public distribution system through poor and marginalized sections, the allocations have seen a significant decline. Okay, so apart from these programs, the other program called National Social Assistance Program. The National Social Assistance Program provides pensions to elderly, widows, disabled individuals. Okay, so This will also provide monetary assistance to families that have lost their sole breadwinner. Okay, so if you look at the budgetary allocations for these schemes, the above mentioned schemes, it as a share of GDP, the central expenditure on school education, whether it is primary education, secondary education, has steadily declined from 0.37 percentage of GDP in 2014-15 to 0.23 percentage in year 2014, 2023 and 24. Okay, so these are the wide variety or wide number of different schemes where the social sector, these allocation in these schemes is very important to improve the social sector, okay, or the social sector outcomes. And since 2014 these schemes were given a lesser allocations, and that will significantly impact the social welfare and the social development. Okay, so however, we have discussed about the healthcare. We also discussed about allocations in Manrega, allocations for the National Food Security Act. So apart from this, however, India has improved its allocations to healthcare sector. India has made a marginal healthcare gains. So if you look at this, healthcare expenditure as a share of total GDP went up by 0.25 percentage in the year 2014-15 to 0.30 percentage. Okay, this is a marginal increase in the healthcare expenditure by the government of India. Okay, now State of World Children Report of UNICEF. The State of World Children Report of UNICEF says that India has the lowest vaccination rates in entire South Asia. Okay, so even though India has introduced the programs like Indradhanush, okay, Indradhanush to improve the universal vaccination in India, it says India has the lowest vaccination rates in South Asia. The total out-of-pocket expenditure on health remains much higher than the global average in India, and this has been pushing millions of people into poverty every year. Okay, so if a person spending higher amount of his income on healthcare expenditure, then it is very it is very revealing that he will be pushed into poverty, or he will be in the chronic cycle of poverty. Now, considerable progress has been made in, however, apart from these challenges, India has made in the recent past a considerable progress on different aspects. Okay, what are those areas? Those areas include access to cooking fuel. For example, India introduced the Ujjwala program. Okay, India introduced the Ujjwala program. So this program provide clean cooking fuel to poor and marginalized women. Okay, so electricity. India has also targeted at improving the electricity outreach to all the villages in India by the year 2022. Okay, so along with that, the financial inclusion of women through self-helping groups, and also the Jan Dhan accounts, Pradhan Mantri Jan Dhan Yojana accounts. So India has made considerable improvements in access to cooking fuel, electricity, financial inclusion of women. Now, apart from that, the World Social Protection Report. This report says that published by the International Labour Organization. Okay, please remember, World Social Protection Report is published by International Labour Organization. So this report says 24 percentage, 24.8 percentage of Indians are covered at least one social security scheme. Okay, so only 24.8 percentage of Indians have covered in one social security scheme against the total average of 44 percentage. So India's coverage is too low or too less than the total coverage in the Asia Pacific. Okay, so it has resulted in India's stagnant human development index. India ranked 132 in the UNDP, United Nations Development Program's human development index, and it has also resulted in significantly increasing the malnutrition levels in our country. Okay, so it is difficult to India to become a superpower. Okay, we have a vision and we have a dream of becoming the global superpower. Okay, so rightly leveraging our demographic dividend. Okay, but with the uneducated and unhealthy population, India cannot achieve the dream of becoming a superpower. Okay, so therefore, in order to leverage our demographic dividend, in order to leverage our demographic dividend, we need to invest significantly on our social sector, especially education, healthcare, midday meal scheme, nutrition, etc. Okay, so this is all this article has been emphasizing upon. Okay, let's jump into the next important news article. Okay, so this news article is with respect to tussle between the elected government in Delhi, and the union government. Okay, so this article first, actually discussing this article, first understand the context of this issue. Okay, recently, the union government says that Delhi does not have, the elected government in Delhi does not have the administrative control over the civil servants. Okay, administrative control over the civil servants. However, the Delhi government filed a petition in a Delhi government filed petition in Supreme Court saying that the center has been obstructing, the center has been curtailing its control over the civil servants in Delhi. Okay, the five-judge constitution bench of the Supreme Court, the five-judge constitution bench of the Supreme Court recently delivered its judgment. Okay, recently delivered its judgment. In this judgment, the Supreme Court says that the administrative control and the functional control over the civil servants is on the Delhi government, okay, the elected Delhi government, but not on the center. Okay, so in this context, there are two articles. Yesterday also we have discussed those two articles. So the first article is Article 239A and Article 239 EAP. Okay, so Delhi, National Capital Territory of Delhi, is distinct from other union territories, because the National Capital Territory of Delhi is a capital also along with the union territory, and it also has a legislative assembly and the elected government. Okay, Article 239 AA provides for the elected government with the legislature in Delhi. Okay, so now please understand Article 239 AA. This was incorporated in the Constitution. Okay, so this was incorporated in the Constitution through 69th Constitutional Amendment Act. 69th Constitutional Amendment Act. Okay, so please understand the aim of the Article 239 and the 69th Constitutional Amendment Act is that the residents of the capital city must have a voice. Okay, they must have a democratic voice and they must choose their own government. So because to fulfill this vision, Article 239 AA is inserted in the constitution. Okay, now it is responsibility of the government of National Capital Territory of Delhi to give expression to the will of the people in Delhi. Okay, so since people of Delhi choose the government, okay, so then the National Capital Territory of Delhi government, it is the responsibility of the government in Delhi to give expression to the will of the people. Okay, so therefore the ideal conclusion would be the government of National Capital Territory of Delhi ought to have control over services, and that include the administrative services. Okay, administrative services or the bureaucracy. Earlier, the center's argument was that the Delhi government have only the functional control over the administration or the bureaucracy. But the Supreme Court judgment says the Delhi government will have both the administrative jurisdiction as well as the functional jurisdiction over the bureaucracy. Okay, so apart from this, legislative and executive power over the services such as IAS, Joint Cadre Services, shall lie with the National Capital Territory of Delhi. Okay, see, the elected government enjoys both legislative and executive power in Delhi. Okay, so therefore, both the legislative and executive power over services such as IAS or joint cadre services shall be lie with or shall lie with the elected government in Delhi. Okay, so postings within the state cadre as well as joint cadre of a constituent state shall be made by government of that state. Okay, so the postings within the state of cadres as well as joint cadre of constituent states shall be made by the elected government in Delhi. Okay, that is duly elected by the that is duly done by the elected government. Okay, by virtue of Article 239 AA, National Capital Territory of Delhi has allocated or has given a sui generis status. Okay, it has given a sui generis status. So since it has given a unique status, it is different, or it is different from the other union territories. So why it is different from the other union territories? Because of few reasons. One is national capital. Delhi is a union territory with the legislative assembly, and also it is a capital city. Okay, it is a capital city, and union government also exercises some sort of control over the union territory of Delhi. Okay, so therefore the term administration cannot be understood as the entire administration of the government of National Capital Territory of Delhi. Okay, so this is the opinion of the Supreme Court Constitution Bench over the administrative control over the bureaucracy. Okay, so the Supreme Court says the term administration cannot be understood as the entire administration of government of National Capital Territory of Delhi. Otherwise, if it is understood as an entire administration, then the purpose of giving powers to a constitutionally recognized or democratically elected government will be diluted or undermined. Okay, so since we have the constitutionally recognized and democratically elected government in Delhi, the powers should be rightly recognized. The powers of the elected government should be rightly recognized. However, if the government is not able to exercise its control, or government does not control or hold account the officers posted in services, then its responsibility towards the legislature as well as public is further diluted. Okay, so this is the other reason, or the second reason given by the Supreme Court. Okay, apart from this, if officers stop reporting to the ministers or do not abide by their directions, then the entire principle of collective responsibility will be affected. The entire responsibility of the collective responsibility will further affected. And lastly, an unaccountable, unresponsive civil services may pose a serious problem of governance in our democracy. So therefore, the Supreme Court has stressed on there is a need for unaccountable and more responsive civil services in the National Capital Territory of Delhi, and the elected government in Delhi should exercise an effective control over the bureaucracy. Okay, it creates a possibility that the permanent executive, in case the bureaucracy is unaccountable and unresponsive, then it creates a possibility that the permanent executive is bureaucracy. Okay, so the administrative structure, that is actually the permanent executive. So the permanent executive consisting of unelected civil services officers, so they may act in ways that regard the will of the total electorate. Okay, so they disregard the will of the total electorate, and this is the opinion or the observations of the Supreme Court in this matter. And Supreme Court ultimately said the elected government exercises the control over the bureaucracy or the administrative structure in the state. Okay, so therefore, to some extent, the tussle between the union government and the center has been settled. Okay, the next is first what this article has been saying. We understood the context. We try and understand what exactly this article has been saying. Okay, so recently the Constitution Bench of the Supreme Court gave a verdict. Okay, so it says that the elected government does indeed have control over the many administrative services. Okay, so the elected government, in this case, the Aam Aadmi Party in Delhi, the chief minister headed by the council of ministers headed by the chief minister indeed have a control over the administrative services. Okay, but the Supreme Court also says that it is limited to services and that are related or that are to the extent the government's executive or legislative powers. Okay, the power of the state legislature or the state government to exert control over the administration is limited to the extent of its executive or legislative powers. Okay, this extends the control over the administration extends to all subjects under both state list and also the concurrent list except three matters. Okay, what are three matters? One is the public order, second police, and third land. Okay, now the court has also emphasized that the national capital territory of Delhi is sui generis in nature. Okay, it is unique in nature, so that the capital territory status is not used to limit the role of elected government. Okay, so in this case, center using the reason of Delhi as a national capital territory it should not limit the powers of the elected government. Okay, so and apart from that, this five judge constitution bench ruling also underlined the principle that representative regime should not be undermined by an unelected administrator. Okay, so the unelected administrator in this case is lieutenant governor. Okay, lieutenant governor. Okay, the principle of overall representative regime should not be undermined the unelected administrator, that is lieutenant governor. Okay, so union government has also passed the government national capital territory amendment act 2001. So the important provisions of the government of national capital territory of Delhi amendment act 2021 we will try and understand in this slide. Okay, now this particular act strengthens the hand of the lieutenant governor. Okay, so this particular amendment which is brought by the union government will further strengthen the hand of the lieutenant governor in running the Delhi. Okay, so it will be source of conflict going ahead, or in future also it will be the source of conflict. Even some of the provisions of the government of national capital territory of Delhi amendment act 2021 were also challenged before the Supreme Court. Okay, so in this context, we shall try and understand what are the provisions of Government of National Capital Territory of Delhi. Okay, so the bill proposes a term, the government. Okay, so the bill proposes a term, a government in any law by the Legislative Assembly. The government means Lieutenant Governor. Okay, so the government means not the elected government, but the government means Lieutenant Governor. The Assembly shall not make rules or committees to consider day-to-day administration or conduct enquiries. Okay, so Assembly also is not empowered to make rules for the day-to-day administration. In case the Assembly make any rules or committees for the day-to-day administration, the new amendment before the new amendment comes into force, then those committees or those rules shall be wide. Okay, this is also the third provision in the Government of National Capital Territory of Delhi Act. So the fourth provision is before actually taking any executive action by the elected government in Delhi, the opinion of the Lieutenant Governor shall be obtained by a general or a special order. Okay, so if they make any executive order, if they take any executive decision, they must obtain the permission. Okay, they must obtain the permission of the Lieutenant Governor. Lieutenant Governor shall have the power to reserve a consideration any bill. Okay, any of the matters outside the purview of the powers conferred on the Legislative Assembly. Okay, Article 239 AA of the Indian Constitution, Clause 4 directly gives a power in case of a difference of opinion between the elected government and the Lieutenant Governor. Then the Lieutenant Governor can refer the matter, the difference to the President. Okay, act according to the directions given by the President. However, the Delhi government says that it also has certain reservations. Okay, so what are the objections from the Delhi government? It says Article 239A says legislature can make laws on any matters. Okay, Article 239A says the legislature, which is formed by the democratically elected government, can make laws on any matters which are in state and concurrent list, except subjects like public order, police, and land. So please also remember the fact that the parliament is empowered to make any law on state list and concurrent list with respect to Delhi. Okay, with respect to Delhi, the parliament have the power, unlike the other states. So, along with the parliament, the Legislative Assembly of Delhi can also make laws on any subject in state list and also in concurrent list. Now, Supreme Court's Constitution Bench in its 2018 judgment recognized the Legislative Assembly's right and said Union has exclusive powers only about three issues. What are the three issues? The three issues are public order, police, and land. Supreme Court has also opined that Lieutenant Governor should work in aid and advice of the Council of Ministers rather than working independently, because Delhi has the elected government, the democratically elected government. So therefore, he work in aid and advice of the Council of Ministers. Now, Supreme Court order clarified that Lieutenant Governor has not been entrusted with any independent decision-making power. Now, lastly, while making matters of a dispute can be sent to the President, the Supreme Court held that it does not mean every matter should be referred. Okay, so in 2018 judgment, Supreme Court held that the normal day-to-day administrative matters should not be referred to the President. The only matters which are constitutionally important should be referred to the president. Okay, so these are the provisions of Government of National Capital Territory of Delhi Amendment Act 2021. These are the provisions, and these are the reservations of the Government of Delhi on the Government of National Capital Territory of Delhi Amendment Act 2021. Okay, so the next article is with respect to the default bail. Okay, this is with respect to the default bail. Now, what exactly the default bail? Okay, so default bail is actually is provided in the section 172 of the Criminal Procedure Code. Okay, so it is mentioned in the section 172 of the Criminal Procedure Code. So it says that the default bill, it says that section 172 of the Criminal Procedure Code says that an accused individual is entitled for default bail if the investigating agency fails to file a final charge sheet. Okay, so for example, a person is accused of a particular crime and he will be arrested and he will be taken into the custody. Okay, he will be taken into the custody, and within 24 hours, this individual is presented before the magistrate. Okay, so after presenting him before the magistrate, either he will be given the judicial custody or the police custody. Okay, see, in this case, he should be either in judicial custody or police custody till the complete charge sheet is filed against this individual. If the investigating agencies or law enforcement agencies unable to provide the complete charge sheet against this individual, if they are unable to provide the complete charge sheet against the accused individual, then he is entitled for a default bail. Okay, so if investigating agency fails to file a final charge sheet, okay, fails to file a final charge sheet against an accused individual within 16 days from the date of remand. Okay, so once this person presented before the magistrate within 24 hours, he will be sent to remand. Okay, so within 60 days, a final charge sheet is not filed by the investigating officers, then he is eligible or entitled for default bail. Okay, he is entitled for default bail, right? So in certain other cases, in certain other offenses, the stipulated period is around 90 days. Okay, mostly it is 60 days, right? So recently, Supreme Court in Ritu Chabaria versus Union of India case. So, in this case, Supreme Court held that the right to default bail under Section 117, 167, 2 of the Criminal Procedure Code, Supreme Court held that it is not merely a statutory right. Okay, default bail is not, not exactly the statutory right, but it is a fundamental right under Article 21 of the Indian Constitution. Okay, so Article 21 is about right to life and personal liberty. Okay, now Ritu Chabaria versus Union of India case, Supreme Court directly says it amounts to the violation of fundamental right under Article 21 of the Indian Constitution, but it is not merely a statutory right. Okay, now in April 26 judgment, Ritu Chabaria versus Union of India case, the Supreme Court held that central agencies like Enforcement Directorate, Central Bureau of Investigation, these central agencies cannot deny an accused person their right to default bail. Okay, so these agencies cannot deny an accused person the right to default bail for filing multiple supplementary charge sheets. Okay, so for example, accused individual 60 days period is completed. 60 days period is completed. Now this person is eligible for default bail. Now the investigating agency has not yet filed a final charge sheet, but has filed a supplementary charge sheet. Okay, a supplementary charge sheet which is part of the earlier charge sheet, and the investigating agency requested the extension of the period of 60 days. So in that case the default bail is rejected, but in this case Supreme Court held that if 60 days completed for an accused person, he is eligible for a default bail, and it is a fundamental right and not merely a statutory right under Article 21 of the Indian Constitution. Okay, now recently Supreme Court said that directed the lower courts. Supreme Court has given a direction to lower courts to decide the pending default bail applications. So across various courts, in lower courts, high courts, there were pending default bail applications. So while considering these applications, Supreme Court has directed that they should not rely on Ritu Chabaria versus Union of India case. Okay, Ritu Chabaria versus Union of India case, the strength of Ritu Chabaria versus Union of India case. Rather, those matters, the default bail applications should be decided independently. Should be decided independently. Why Supreme Court says this? Because Supreme Court already declared that it is a fundamental right under Article 21. Okay, so this is a right. This is a matter of right. So in this case, the courts cannot reject a person default bail. Okay, so this otherwise poses a threat to the national security or even change the course of any case. So therefore, keeping all these factors in mind, the Supreme Court has given directions to the lower courts that while deciding the default bail applications, they should consider the matters independently. Okay, they should consider the matters independently and do not take upon the strength of Chabaria case. Okay. See, because any judgment of the Supreme Court is actually considered as the law of the land. Under Article 141 of the Indian Constitution, it provides for a law declaring Supreme Court shall be binding on all courts within India. For example, in a particular judgment, Supreme Court delivered a piece of judgment. Okay, Supreme Court delivered a piece of judgment, and it will be binding on all the courts, all the lower courts in India. Okay, so this is provided in the Article 141 of the Indian Constitution. In default bail case, if Supreme Court come up with such a judgment that it is not merely a statutory law, it's a statutory right, but is a fundamental right under Article 21 of the Constitution, then all the courts should started following the Supreme Court judgment. Okay, Supreme Court judgment, because the Supreme Court judgment is considered the law of land, and the law declared by the Supreme Court shall be binding on all courts within India. So keeping this in mind, the Supreme Court in its latest judgment in May 1 held that this bench was led by Chief Justice of India, D.Y. Chandrachud. Okay, so this bench directed all the courts to defer any decision on default bail applications filed on the strength of Ritu Chabaria judgment. Okay, so while deciding the default bail applications, those applications should be decided independently, case by case basis, and they should not be based on the strength of Ritu Chabaria judgment. Okay, because it will have significant implications. Because our enforcement agencies to some extent does not have enough capabilities or enough efficiency or investigation expertise or the professionalism. So because of all these factors, they may not be able to file a final charge sheet on a particular accused individual. So because of this reason, the accused individual will claim a, a default bail as a matter of fundamental right. So this will have a significant implications on our legal system. Okay, so therefore, because of this reason, the Supreme Court has directed the lower courts that those matters of default bail should be decided on the independent basis and on the basis of the merit of the case. Okay, so the May 1st order had prevented courts from deciding default bail pleas independent of the Ritu Chabaria judgment. Okay, so they should be independent of the Richa Chabaria judgment. So this is all with respect to the default bail. So you understood what is a default bail and Article 141 of the Constitution and any judgment of the Supreme Court is actually considered as the law of the land. In fact, the default bail has been mentioned in section 167 clause 2 of the Criminal Procedure Code. Okay, so and Supreme Court in Ritu Chaparia versus Union of India case also held that the default bail is not merely a statutory right, but it is a fundamental right under Article 21 of the Indian Constitution. Okay, so with this information, let's discuss the next very important news article. So the next important news article is with respect to the Internal Complaints Committee. Okay, this is with respect to the Internal Complaints Committee, and these internal complaints committees have been mandated by the Sexual Harassment of Women at Workplace Act 2013. Okay, so this act mandates that if a company have 10 employees, and the company must constitute the internal complaints committee. Okay, so recently the Supreme Court referred to a newspaper survey. Okay, recently Supreme Court referred to a newspaper survey, and this survey has revealed that out of 30, this newspaper has revealed that out of 30 national sports federations in the country, only 16 had constituted. Out of out of 30 national sports federations in the country, only 16 had constituted the internal complaints committee under the 2013 Prevention of Harassment of Women at Workplace Act. Okay, so taking note of this, the Supreme Court expressed the displeasure over the actions or the measures taken by both center, both center and state governments over constituting the internal complaints committees in different ministries, departments, and administrative bodies. Okay, so as part of this article, we will discuss what exactly the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act of 2013 mandates. Okay, now please understand this. If an organization have 10 employees, then that organization must constitute an internal complaints committee. Okay, that organization must constitute an internal complaints committee under the Sexual Harassment of Women at Workplace Prevention, Prohibition, Redressal Act 2013. Okay, so it mandates the internal complaints committee being set up under section 4 of the Sexual Harassment of Women at Workplace Prevention, Prohibition, and the Redressal Act. Okay, so if any company does not meet the regulation or does not meet the directions under the sexual harassment of women at workplace, then a fine of 50,000 or more will be imposed on such organization, and it will also lead to the cancellation of license and registration of a firm or an organization. Okay, now what happens is, generally, when a woman reported of abuse or sexual abuse or sexual harassment against her to internal complaints committee, generally internal complaints committee will investigate the matter. Okay, so this will investigate the issue and then provide justice for the woman. If the matter is serious, then the internal complaints committee will encourage the worker to complain, to register a formal complaint against her co-employee. Okay, now it also suggests that the following steps can ensure safe work environment for women. So what are those steps? Treat sexual harassment as a misconduct and initiate required action. Okay, so every company, every firm or organization should treat sexual harassment as misconduct and initiate required action, and organize workshops, awareness campaigns to disseminate awareness and information about the sexual harassment of women at workplace, and also conduct campaigns, and also make the male employees more and more sensitive or sensitize them about the sexual harassment of women at workplace. Now discuss this article. The Supreme Court on Friday in one of its judgment held that there were serious lapses and uncertainty. Okay, serious lapses and uncertainty in the implementation of prevention of sexual offenses, sexual harassment of women at Workplace Prevention, Prohibition and Regulation Act 2003. Okay, Supreme Court uh, found out that there were serious lapses and uncertainty in the implementation of the said act. Okay, so this lead to many working women with no choice but to leave their jobs. Okay, so we have a significant pay gap between male employees and female employees, and also a huge gender inequalities. Okay, gender inequalities when it comes to women participating in the workforce. Okay, so in this scenario, the sexual harassment or sexual abuse of women at workplace making women leave their jobs with no choice. Okay, so it also denting their self-esteem of a woman. Okay, of a woman employee, it dents their self-esteem, and it also takes toll on her emotional, mental and physical health. Okay, so it is often seen that when women face a sexual harassment at workplace, they are reluctant to report such misconduct, because they are reluctant to report such a misconduct is primarily because uncertainty about whom to approach, and even they lack the confidence and the trust over the internal complaints committee, whether they resolve, whether they provide justice to the woman employee or not. So because of these reasons, there was a huge uncertainty about whom to approach, and women employees also lack confidence. So because of these reasons, the spirit of the prevention of sexual harassment against women in offices or at workplaces is not properly implemented. And the court has also directed the union government, states, and also union territories to undertake a time bound exercise to verify ministries, departments, government organizations, authorities, and public sector undertakings, institutions, and bodies to constitute the internal complaints committees, mandatorily constitute the internal complaints committees, local committees, and internal committees. All these committees have been mandated under the Prevention of Sexual Harassment of Women at the Workplace Act 2013. Okay. However, the Supreme Court has also ordered that these bodies have to publish the details of their respective committees in their websites. Okay, all the bodies, all the organizations which we already discussed, they should publish the details about the internal complaints committees, and local committees and internal committees should be published in their websites, and they were given a time frame of 8 weeks to comply with this orders of the Supreme Court. Okay, so this is all with respect to the internal complaints committee and prevention of sexual harassment against women in Workplaces Act 2013. Okay, with this information, let's discuss the next important news article. Okay, so this is with respect to the Model Prison Act. Okay, this is with respect to the Model Prison Act. Okay, so recently Ministry of Home Affairs have drafted the Model Prison Act. Okay, so this Model Prison Act will replace the colonial era Prison Act. Okay, so the Colonial Era Prison Act over 130-year old. Okay, this act is over 130-year old. So because of this reason, the Ministry of Home Affairs have come up with such a Model Prison Act 2023. Okay, 2023. Okay, so this will replace the British era law to overhaul overall prison administration. Okay, so this will overhaul overall prison administration, and the focus will be on reformation. Focus will be on reformation and rehabilitation of prisoners. Okay, rehabilitation of prisoners. Now, the salient features which are mentioned in the Model Prison Act include the punishment for prisoners and jail staff for use of prohibited items in prisons, such as mobile phones in jails, and also establishment and management of high security jails. Okay, so this also envisioned the establishment and management of high security jails. Thirdly, there will be a provision of open jails and also provision for protecting the society from the criminals. Okay, so it also consists of a provision for protecting the society from criminals and habitual offenders. And finally, this Model Prison Act also comprises, or it also consists of provisions with respect to providing legal aid to prisoners. Okay, so in India we have a huge problem of under trials. Okay, under trial. Okay, so the under trial population or under trial prisoner is very high, is because they lack a legal aid. Okay, they lack proper legal aid. And since they lack the legal aid, the Model Prison Act also mandated that it will provide legal aid for the poor and marginalized sections of the society. And apart from this, the Model Prison Act will also incentivize good conduct of the prisoners. Okay, so we have discussed that this will replace the 130-year old Prison Act of 1894. Okay, so it will replace the 130-year-old Prison Act of 1984. Okay, so this is actually a pre-independence era act, and it is almost a 130-year-old act. So apart from that, there are two other related laws. Okay, so one is the Prisoners Act. Okay, Prisoners Act 1900, and also apart from this there is a other act, Transfer of Prisoners Act. Okay, Transfer of Prisoners Act, and this Transfer of Prisoners Act was passed after independence in the year 1950. Okay, so please remember management of jails and prisons under the state list. Okay, prisons under the state list. We have a state list, concurrent list, and a union list. Okay, jails and prisons are under the state list. Okay, so this act, the Model Prison Act, will serve as a guiding document for states. Okay, since jails and prisons are state subject, the Model Prison Act will serve as a guiding document for the states. Okay, so that the states can emulate the best practices which are provided in the Model Tenancy Act. So therefore, reforming and rehabilitating how jails are actually organized. Okay, so there were actually several lacunas in the existing Prisons Act. Okay, so there was a conspicuous omission of correctional focus on the existing act. Okay, now the current or the existing acts, they are exclusively focused on the custody of the individuals, or they focused on the punishment itself, but they largely neglected the rehabilitation and reforming aspect, and also providing any skills so that if they come out of the jails they can live a decent and a dignified life. Okay, so in this respect, we try and understand some of the significant provisions with respect to, or some of the significant advantages or benefits with respect to the model tenancy, with respect to the Model Prisons Act. Okay, so the benefits of Model Prisons Act 2023 includes the following benefits. Okay, so the the NDA government at the center has prepared, or the Ministry of Home Affairs has prepared uh, a Model Prisons Act 2023. Okay, so this will change 130-year-old prison laws. Okay, some of the benefits of the Prison Act 2023 include: new act have focus on vocational training, skill development of prisoners. Okay, so this will help them reintegration or reintegrate them with the society once they were out of the prison. Okay, so this will also have a provision of legal aid for persons, okay, for prisoners. For example, several prisoners belong to poor and marginalized communities. If they does not have a legal aid, even though they are eligible for receiving bail, okay, even though they are eligible for receiving bail, they will not get bail, and this will further increase the under trial population. Okay, this will further increase the under trial population in prisons. So therefore, this bill has envisioned providing legal aid for prisoners, and this also has a provisions with respect to parole, furlough, and premature release, etc. Okay, so this Model Prison Act will also incentivize the good conduct on the part of the prisoners. Okay, so finally, this also have a provision of protecting society from criminal activities of hardened criminals and habitual offenders. So apart from this, the other benefits of the Model Prison Act include the 2023 include provision of video conferencing with courts, scientific technological interventions in prisons. So there will be technological interventions in prisons as well, and provision of punishment for prisoners and jail staff if they use prohibited items such as mobile phones in jails. Apart from that, it also consists of a provision regarding establishment and management of high security jail and open jail. Okay, so it will have a provision for high security jail and open jail. So in the present context, open jail has been gaining traction. Open jail have been gaining traction, and this open jail will help make reform the prisoners and also rehabilitate them, and will also provide vocational training or technical knowledge to the prisoners, so that it will be helpful for them to reintegrate with the society. So other benefits of the Model Prison Act includes: it will lay more emphasis on safety of women and transgender persons who are in prisons. So apart from that, it will also ensure rehabilitation of inmates in society after completion of their sentence. And finally, it will bring transparency in prison management by using technology. Okay, so technology will be extensively used to bring in transparency in overall prison management. Okay, so this is all about the Model Prison Act. See, all these provisions are very important for mains exam perspective, especially in paper 2. Okay, so please go through all these points and remember these points. Now, the next important news article is with respect to the inflation. Okay, so inflation is generally known as the general rise in prices. Okay, it says that inflation slips to a 18-month low of 4.7 percentage. 4.7 percentage. So, if you remember, actually, the target of the Reserve Bank of India is 4 percentage inflation with upper and lower tolerance levels of +2 and -2. So with the inflation of 4.7 percentage, it is within the limits prescribed to the RBI by the central government. Okay, so India's retail inflation slide to an 18-month low of 4.7 percentage. Okay, this 4.7 percentage is an 18-month low. Okay, now, this is actually below the Reserve Bank of India's 6 percentage tolerance threshold for price rise for the second successive month. Okay, so this is primarily because of the base effect. Okay, the inflation is within the limits is primarily because of the base effect. So what is the base effect? We will discuss the base effect. So generally, lower inflation is normally good for the economy or not. So when it comes to higher inflation, what happens is that the demand in the economy will be further decline. Okay, demand will decline in case of a higher inflation. In case of a lower inflation, the demand will pick up. Okay, demand will pick up in the economy, and this will make the production, it will further increase production, and it also incentivizes the economic growth. Okay, it will also incentivizes economic growth and will also create a large scale employment in the economy. Okay, so therefore inflation should be it should not be either too high or it should not be either too low. Okay, now understand what is exactly the base effect. Okay, base effect. So base effect is actually a distortion in the current inflation figure. It is actually the distortion in the current inflation figure, and it is caused by exceptionally high or low levels of inflation in the previous reference period. Okay, now imagine this figure is with respect to April inflation of 2023. April inflation of 2023. Now, in the same period of the previous year, April 2022, April 2022, if there is a lower inflation, or if there is a higher inflation, then this will also have an impact on the inflation in the year 2023. So this has been effectively conveyed here. So in the context of inflation, the base effect is distortion of current inflation figure. This is actually the current inflation figure is being distorted, and it is caused by the exceptionally high or low levels of inflation in the previous reference period. Okay, so higher low levels of inflation is impacting the next year inflation is actually called as the base year. Okay, so for example, imagine if the inflation rate was too low in the previous period of April 2022, and then the corresponding period of last year, and even a small increase in the price index will give high rate of inflation in the current year. Okay, so this is actually the base effect. Now, with respect to the consumer price index, and the consumer price index is actually measure the price change from the perspective of retail buyers. Okay, so it measures the price change from the perspective of retail buyers, and it is released by National Statistical Office. Okay, so please remember it is released by National Statistical Office. So we have the consumer price index and also the wholesale price index. Now wholesale price index is released by the economic advisor of Ministry of Commerce and Industry. They release the wholesale price index, and releases National Statistical Office releases the consumer price inflation. Now consumer price index calculates the difference between price of commodities and services. Please also remember the consumer price index consists of services. On the other hand, the wholesale price index does not consist of services. Okay, now consumer price index considers the difference of price of commodities and services such as food, medical care, education, electronics, which Indians consume by for use. Okay, so there are consumer price index have several subgroups that include food, beverages, fuel, light, housing, clothing. Okay, so four types of CPI include the CPI for industrial workers, CPI for agricultural workers, CPI for rural laborers, CPI for rural, urban, and combined. So on these, the first three, that is CPI for industrial workers, CPI for agricultural workers, and CPI for laborer, is compiled by Labour Bureau of Ministry of Labour and Employment. The fourth is compiled by National Statistical Office, Ministry of Statistics and Program Implementation. So this is all about the inflation. Okay, this is all about the cooling down of inflation, and especially the consumer price inflation at the retail level. Okay, retail level. So these are all important and relevant news articles for today's discussion, and thank you.